Dear students and dear online participants, welcome to already the 5th lecture to our lecture series on strengthening EU environmental law. Today, the focus will be on whether and how member states can take more stringent action compared to EU environmental law. The lecture will be delivered by Professor Leonie Reins from the Erasmus University Rotterdam, the Netherlands. Leonie is a well-known EU environmental law scholar, and I have met her at conferences throughout Europe and engaged into great discussions with her. Leonie has co-edited with Professor Geert van Kalster the handbook EU Environmental Law, but she also delivered many more books, many articles, as you can see on her web profile. She also delivered a contribution to the research handbook on EU environmental law on the topic which she will be addressing today, which concentrates on a seemingly simple provision of the TFEU, Article 193, but which is truly hard to understand. Therefore, Leonie, thank you for your willingness to share your insights on this topic with us, and I invite you to take the floor.
Welcome, everyone, and thank you very much for this super kind introduction of Professor Marianne Peters. It's really an honor for me to be here, and I thank Marianne Peters and the entire Green Deal team for the invitation. As Marianne already kindly introduced, my presentation has the fancy title, Where Eagles Dare, and how much room is there for member states under the environmental guarantee. And actually, my talk connects very well to the overarching topic of the lecture series, Strengthening EU Environmental Law, because it is precisely actually about that, about strengthening it. In a nutshell, generally under EU environmental law, member states have the ability to go further than what is included in EU law. And we are exploring here the conditions on which ground this is possible and what further actually means. It also connects to the lecture given by Professor Helle Tenger-Anker on competences, albeit in a very different context. I guess without much further ado, let's get started. The aim of today is to first of all get a general understanding about the environmental guarantee, but also a bit more than that, namely to understand how the Court of Justice of the European Union has interpreted this provision in the past. And spoiler alert, there's a lot of case law on it, and also how it has been used in secondary law. So the main objective is really to understand whether it's an effective tool for the protection of EU environmental objectives. And in order to explore that question, I will first of all give a very brief historical background and context to the provision. Then we will directly jump into the dirty work that the court had to go through, the interpretation of the measure. And before concluding, we will also delve into the use of the environmental guarantee in EU legislative instruments. But first, let's take a step back and look at the environmental guarantee and what it actually is. So therefore, we have to open, I guess, digitally open here, Article 20, Title 20 of the TFEU on environmental policy. And here, as you probably all know, we have the environmental objectives and the environmental principles. So the objectives are the ones here on the slide: preserving and protecting and improving the quality of the environment, but also human health, natural resources, and also to deal with climate change worldwide. And then in the second intent, we see here that the union policy shall aim at a high level of environmental protection, and also taking into account the diversity of the situations. And then we have the classical principles, which you all know. So now, if we go a bit further and skip Article 192 on the decision-making procedure, we get to Article 193, which states that the protective measures adopted to Article 192, so the decision-making procedure, shall not prevent any member state from both maintaining on the one hand and introducing on the other more stringent protective measures. Such measures should be compatible with the treaties and they shall be notified to the Commission. So as Marianne kindly said in the introduction, it looks like a very easy and straightforward provision, but unfortunately, it's actually not. And I've been dealing now a long time with it, and there are other heroes, for example, Lorenzo Squisiani, who has written an entire PhD on it. And still, let's see at the end of the lecture, there's still a lot of unclarity around it. But now I'm going a bit ahead of myself. Let's go back a bit to the origins. So this provision is commonly referred to as the environmental guarantee. That is not the scientific name, but I guess this is what the provision is understood to. And it was first introduced in the European Single Act in 1986 and was drafted on the request of the EU member states that had a rather high standard of environmental protection. So, for example, Germany, but also the more northern member states of Sweden and Finland. And the original intention of this provision was to really reassure these member states that their environmental goals would not be watered down or have been raised to the bottom of the protection standards when EU law is applied. So that was the original idea, to reassure them that they can maintain or introduce more stringent measures and that EU law wouldn't water down their environmental goals as they were standing at the time. So while the environmental guarantee was already introduced in the Single European Act, there it wasn't really used a lot and also not really relevant, and it actually only became relevant with the Maastricht Treaty in 1992. And that was because prior to Maastricht, environmental legislation was subject to unanimity voting, as you've also discussed. So that means that member states, when considered that the proposed EU environmental measure was either too strict on the one hand or not strict enough on the other hand, member states could simply block it. However, then with the introduction of qualified majority voting, this was not longer an option, except obviously for those provisions which are still subject to unanimity. Before we continue with interpretation of the court, I think it's also important to mention that the environmental guarantee contained in Article 193 is not the only environmental guarantee contained in the EU treaties. We, for example, find another one in Article 114, which is in relation to the internal market measures and the approximation of law. So there it's also about introducing or maintaining other measures. And you could say that some of the characteristics, scope, and requirements for the application of the environmental guarantees in both provisions are similar, and others actually differ quite a bit. So, for example, contrary to Article 114, in Article 193, there's no requirement for new scientific evidence relating to the protection of the environment, as is included in this provision, or also not that the problem needs to be specific to one member state after the adoption of the harmonization measure. So what is similar for both environmental guarantees is that the burden of proof to actually illustrate that the more stringent protective measure introduced is compatible with the treaty lies within the member states. So I think that is important to be kept in mind. And generally, one can say that the environmental guarantee under Article 193 seems easier to apply than the one under Article 114. But there are also quite some constraints, which we will be now discussing in the following. Okay, that is the provision again. Let's jump into the interpretation of the court. So in order for the environmental guarantee to be lawfully used by the member states, there must be 3 conditions fulfilled. First of all, the more stringent protective measures adopted by an EU member states. Then the second one, that it must be compatible with the measures in the treaties. And lastly, that a notification of the measure. On that note, actually, some authors, such as Lorenzo Squisiani, which I already mentioned, who is the hero of the environmental guarantee, sees requirements 1 and 2 together, and they say, at least in practice, from a practical point of view, this distinction is not really relevant. I definitely see their point here, but I think for our teaching purposes, it's easier if I just take them in turns so that it's easier to also see which case law relates to which provision. Okay, let's start with more stringent measures. Literature suggests that they can actually be a multitude of things, and David Langelt and his co-author and also de Sadelaar have included a list in their writing. And examples that they say is, for example, the possibility of extending the scope of application of a particular union standards, such as, for example, stricter emission standards under the water quality, for water quality, stricter emission standards on the other hand, one hand under the Air Quality Directive, and on the other hand, stricter water quality standards, as for example, under the Water Framework Directive. Then another possible stricter measure is the passing of stricter thresholds, for example, for air quality. And we will actually zoom into the Air Quality Directive later on. So if you would actually say that you would want currently the threshold is 500 microgram cubic meter for sulfur dioxide. And if you want to amend this threshold, that would be as more stringent measures. A third example is the establishment of more stringent procedure requirements. So, for example, additional monitoring or reporting or verification environment, or also making more parties concerned parties than that is currently done in some member states. Another example is the list or establishment of a list of more substances to be regulated, for example, more chemicals under the REACH regulation, or more activities to be acted, for example, activities which would fall under the Industrial Emissions Directive, or additional activities under the Environmental Liability Directive. A third element that is mentioned in literature is the removal of exceptions established under an EU measure, or, for example, also setting of earlier time limits than these are included in the EU measure. However, I think I want to really stress and repeat that the treaties themselves do not contain a definition of the term more stringent protective measures. And also the European Commission has not provided any guidance on the issue either. So therefore, the role of the court in further fine-tuning the meaning of the environmental guarantee is really important. And this is what we will now jump into in the following. So what are more stringent measures? And maybe even more importantly, what are they not? That is the crucial question. And the court, as I said before, has given a lot of case law on this. And generally, measures who seek to achieve the same environmental objective as the one pursued at union level seems to be more stringent. So this means when a certain level of protection has been set at the union level, member states may only go beyond the level of that protection by adopting measures which are in support of this objective. So that actually means, on the other hand, that member states cannot be less ambitious than the union measure, but they also, and I think this is less clear, cannot change the arrangements for implementing secondary law. So they cannot adopt a better measure, whatever better may be in a specific context. So it can really only go higher standard than those adopted by the union measure. Further, and we will get back to that in a bit more depth, it does also not release member states from the obligation to transpose the directive. And what I mean by that, we will discuss in a bit more later. So I think the clearest articulation of the test of the control of the lawfulness of the use of the environmental guarantee was provided in 2005 by the court in a case called Deponiezweckverband Eiterkopfe, very interesting name. And here the court was asked to provide a primary ruling in the context of proceedings between a German court, the Verwaltungsgericht Koblenz, concerning the authorization to operate a landfill slide. And here the court actually held that it is clear from the broad logic of Article now 193 in the previous version of the treaty. So before Lisbon, this was actually Article 176 of the EC, that in adopting stricter measures, member states still exercise power governed by community, now union law, given that such measures must be in any case compatible with the treaties. Nevertheless, it falls to the member states to define the extent of the protection to be achieved. So in this ruling, the court considered that as long as the German measure at issue fulfilled the same environmental objective as included in the directive, also the stricter measures than those included in the directive continued more stringent measures. So again, stressing same environmental objective, not better objective, not a different objective. So for example, and that was also a finding from literature, that to the extent that the directive included the terms then note later then, member states were actually permitted to adopt stricter time limits and therefore more stringent form of protection. And the court in this case also concluded that when parts of a measure were individually compliant with community, now union law, that there were no grounds for regarding them collectively as contrary to community law. And furthermore, the court made explicitly clear that the principle of proportionality, which you all know, which is generally applicable in cases of member states' actions seeking to derogate from union obligation, is not applicable, and I repeat, is not applicable as far as the most stringent measures of domestic law is concerned. It is only important when it comes to complying with the minimum requirements of the EU measure itself. So I repeat again, because that is an interesting point and we'll get back to it. So the proportionality principle is not applicable as far as the more stringent protective measures of domestic law is concerned. It's only important when it comes to complying with the minimum requirements of EU law. And we will get back to that with a concrete example to illustrate you what that actually means in a bit. So just keep it in mind for now. Another interesting case in this regard is the safety high-tech case. And here the court actually held that the EU level of protection does not necessarily have to be the highest that is technically possible. So if EU member states may wish to achieve the level of protection that is the highest one that is technically possible, they can do that. So they can go beyond that. But the EU measure itself does not have to be aiming at the highest technical level possible. did I skip a slide? No. For NASA and others, the court considered the question of the extent of the harmonization measures that is achieved by the union instruments when a more stringent measure is at stake. And in this case, the court was called to answer the question whether the Hazardous Waste Directive actually prevented EU member states from unilaterally classifying waste as hazardous, in addition to the hazardous waste that was already included in the directive. So additional waste to be classified as hazardous. And here the issue was whether the member states couldn't act more stringent protective measures in order to prohibit, for example, the abandonment, dumping, or also uncontrolled disposal of waste. And in this case, the court analyzed the basic principles of EU environmental law, including actually the precautionary principle. And it then recalled that the applicable EU legislation does not seek to effect complete harmonization in the area of the environment. And hence the list of hazardous waste provided for of the directive entitles member state to classify any other waste which the member states considers to display certain characteristics as being as hazardous. However, the court in the same ruling also made clear that such waste is then only considered hazardous in the territory of that member states and not within the entire union. Otherwise, it would significantly restrict intercommunity trade. I mean, the court didn't use that last sentence. That is what I'm editing as an explanation. So just saying that it was only hazardous in that territory and not in the entire member state. And then in the SKO Energo case, the court dealt with the question of the importance of the similarity element between the objective pursued by the EU environmental instrument on the one hand, and with the similarity of the EU measure claimed to have adopted more stringent protective measures on the other hand. And in that case, Czech law imposed a gift tax of 32% on freely allocated emission allowances as part of the EU ETS directive, and therefore included an exemption for solar photovoltaic power stations. And here, the court actually held that in principle, this was contrary to the directive, but it was ultimately up to the national court to decide. And in its reasoning, the court found that the national measure which has been pursued has an entirely different objective from that was originally included in the ETS directive, and it wouldn't be an incidence of Article 193. And the court, as you can see here also on the slide, said that a measure was intended to obtain additional revenues for operators of photovoltaic stations, and it was hence, as I said before, a different objective from the EU ETS directive, which is establishing EU emissions trading framework and contributing to emissions reduction on the long run. So different than additional revenues for operators of photovoltaic power stations. So that was a restrictive interpretation of how the Article 193 could actually not be used. And now actually it's the last case regarding the first element of this very complicated provision, the more stringent measures. So in the Commission and Poland, the court dealt with the argument by Poland that the court were to rule, in the case that the court were to rule that Poland had not adequately transposed the GMO directive, as Poland obviously claimed it had done, the provisions of the Polish law in any event would be more stringent. This is what I already said at the beginning. The court had rejected here Poland's argumentation and held that if a member state didn't at all transpose the directive, they can also not rely on Article 193 altogether. So If you didn't transpose the directive, you can also not say, in any event, our national law that we had is better. So that doesn't work. And therefore, you could actually say that the court has established the partial transposition, at least, of directive into a national law as a precondition for being able to rely on Article 193. Okay. Then let's now, after having discussed the case law on this first bunch of the provision, the more stringent protective measures, jump to the second part. And the good news is that there's not so much case law, so the most difficult part is already behind you. So the second component mentioned is that measures must be compatible with the treaties. So not only with the environmental objectives included in the treaties, but also with the other objectives included there, such as the free movement of goods, harmonization, competition law, taxation rules, etc., etc. So all other objectives. So this was dealt with in a case called Düsseldorf and others. And here at issue was the export restriction that was included in the Dutch long-term plan for disposal of dangerous waste, which was a plan from 1993, so quite an old plan, but that doesn't matter. And the plan actually had the effect that the export of waste would not be permitted at all unless the processing of oil filters would be superior than those performed in the Netherlands. So here the court found that the export restriction itself was not necessarily for the protection of health and life and humans in accordance with Article 36, which is the prohibition of quantitative restrictions. So therefore, the measure was incompatible with the free movement of goods, and it could also not be afterwards remedied by relying on imperative reasons to protect the environment and human health as provided for in Article 36. So here the reasoning was not directly on Article 193 itself, but that it also had to comply with other principles of the treaty, such as the free movement of goods. So consequently, Düsseldorf was another case which actually had a restrictive interpretation of the nature of the environmental guarantee on grounds that it was not compatible with the treaties as such. And this case was actually confirmed in a case called Tridon. The case is more relevant for the external dimension division of competence, so I won't discuss it in great detail here. But here the court followed a similar line of argumentation as in Düsseldorf, saying that an absolute trade prohibition of trade with captive and bred species, endangered species, was going too far to protect the environment. And in this case, the court said that a national rule cannot benefit from the derogation provided for in Article 36 if the health of life and animals can also be protected just effectively by measures which are less restrictive than trade. So here you can see again the balance between environmental protection concern on the one hand and the effect it could have on trade. In a case called TFEU, and I think that's completely horrible, wrongly pronounced, so I apologize for any native speakers in the room. The court considered actually the question of compatibility with the treaties in the context of Article 16 of the Environmental Liability Directive. And Article 16 of that directive is actually explicitly discussing the relationship between national liability law for the environment and the EU liability directive. And here, actually, the court held that environmental liability did not preclude any measures that, for example, specifically identify other categories of persons beyond that already mentioned in the directive, which were liable for an environmental damage. So one could also claim other persons than those included in the directive to be liable. And also it provides for the possibility for national authorities to impose fines also on owners in addition to the users of land. So that's again two more stringent protective measures under environmental liability. But now it becomes interesting again in that case. However, the court also stated, and it's also cited here on the slide, that such measures are, and now, yeah, appropriate for the purpose of contributing to the attainment of the objective of more stringent protection, and that the methods for determining the amount of the fine do not go beyond what is necessary to attain that objective. So if you read this provision very carefully, you might have remembered that there's an element of proportionality here. And at the beginning of the lecture, I told you that proportionality is only an element when we look at the EU measure itself and not into the domestic measure. So here you could actually say that this wording could be considered as a reintroduction of a proportionality test against what the court had explicitly held in Deponiezweckverband, that this principle does not apply to more stringent protective measures in domestic law. Whereas this finding was already challenged in other cases, such as ERC2, which I didn't discuss here. Here in this case, the court explicitly stated that the national measure must also be compatible with the general principles of EU law, which of course also includes the proportionality principle. So that's an interesting turn of the case law of the court itself. And another interesting question arises, not only with regard to the proportionality principle, but also with the question whether fundamental rights also need to be protected, respected in the context of the environmental guarantee. And this was discussed explicitly in 2008 in Advocate General Cocotte in her opinion on the Talina Vesi case, and she answered the question with a clear yes. However, then in the ruling, the court neither referred to the concept of more stringent protective measures and also not to the question whether such measures need to be respect EU fundamental rights. However, actually, in my opinion, it's a logical conclusion. First of all, as I've now said a couple of times, fundamental or general principles of EU law also include fundamental rights. And secondly, the EU and the member states have to respect fundamental rights in all situations. So also in situations where more stringent measures are adopted. Okay, so this was the case law regarding the compatibility with the treaties. Now, and that's good news, there's only one case left to discuss for this part of the lecture, which is dealing with the notification requirement. And here in that case, in the Azienda case, the court dealt with an Italian measure that imposed an absolute provision on the construction of new wind turbines in Natura 2000 areas. So, and you already discussed that as well, the Natura 2000, or I think you will otherwise. The measure went beyond what is provided in Article 6 of the Habitats Directive, and therefore the court constitute a more stringent protective measures in the sense of Article 193. However, Italy did not notify the measure. So that was the issue here. So not on the interpretation of the measure itself, whether it constitutes one, but really on the notification requirements. And here, in this regard, actually, the court held that neither the wording nor the purpose of Article 193 provides any support for the view that a failure by the member states to comply with the notification obligation in itself renders lawful the most stringent protective measure to be adopted. So I guess that is good news for everyone who wants to take more stringent measures, that if you forget to notify them, it doesn't necessarily mean that the measure is lawful to start with. However, Article 193, unlike Article 114, also does not require that the grounds for the introduction of the envisaged more stringent measures have to be notified as well. Hence, it can actually be argued that a simple notification of the more stringent measures without providing any reasoning thereto is enough anyways. So you don't need to, according to primary law, and I stress that because we would have a second part of the lecture as well, there's no notification requirement included. Okay, let's do a quick recap for this part of the lecture, the court case part. So I think we can agree, by having gone through all these cases, that the case law of the court has greatly contributed to the shaping of the environmental guarantee. It clarifies what it means to be in accordance with the treaty, namely to comply with the general principles of EU law, but also fundamental rights. In accordance, that the measure has to be in accordance with Article 34 to 36 of the treaty, which is indeed the prohibition of quantitative restrictions between member states. It hence must also respect the rules regarding free movement and trade, and cannot be considered an arbitrary restriction on the trade. And the measure must be in line with the nature of the harmonization objective of the relevant secondary legislation. And in this sense, it cannot be different. And I think de Sadler phrased this very well. He said that the measure must be consistent in the extension of the harmonization rule by pursuing a greater level of environmental protection. So again, not different, but an extension of the rule. So far, the case law. Now we will delve briefly in the time that we've left, zoom into the environmental guarantee in the EU legislative instruments. And actually, I'd like to start with a question to get you thinking a bit after this part. Can or may a directive prohibit EU measures from Can or may a directive prohibit EU member states from adopting a more stringent protective measures? If we look at the case law, if we look at the primary law, I guess the answer is a clear no. It literally says in here that it shall not prevent any member states to adopt more stringent measures. What is interesting in this regard is that scholarship largely is of another opinion. So Langet, for example, says that there's a clear risk that the functioning of the internal market is undermined if indeed member states are allowed to apply more stringent measures in all situations. And this view is actually similarly also supported by Jans and Feder. And Holwerda, a colleague from Groningen, even went further than that. And he said that the jurisprudence on this matter is inconclusive and unclear. So that's an open question, and some light actually on it will be shed if we continue now with looking at how the environmental guarantees has actually been included. And what is interesting is in this regard that the EU legislator has opted more and more to include the possibility to adopt more stringent protective measures in the legal instruments itself. So most of the time in the recitals, as you can see in this table, which is actually by no means exhaustive, it's really just some examples that I found interesting for particular reasons, which we'll go into in a bit. And you will see here also that it's typically done in regulations and directives, but also it shows one international agreements between the Union and third countries. I tried to find a logic, trying to see when are they included in the recital and when not, because as I said before, it's not included in all environmental legislation. But so far, I haven't succeeded yet. So I can't help on that. That is, I guess, to be further thought about. What I will go now is provide you with 3 examples that I've included in the table, which I think are particularly interesting. And the first one relates to the proposal for the revision of the Air Quality Directive, which I've been hinting in. So here, Article 193 is actually referred to in 2 instances. First of all, in the recital as the preamble, as when you have seen the list, this was normally the case. Here, it's just for the codification in the secondary law, what is already included under primary law. However, if you look at what has been replaced in this proposal, it becomes apparent that in the past, only more stringent protective measures were possible regarding certain pollutants. So that relating to our first question, can the member states prohibit, can a directive prohibit? Here it seemed to have, at least in the past, prohibited for other pollutants than those included. This has now been removed again to make the scope of Article 193 broader, or actually not broader, but as intended, back to as intended in primary law. And in a way, the previous version limited the reach of the article, but I think it's also interesting that apparently no member states had to have a problem with that. At least there's no case law on this. And also I tried to find an answer in the travaux préparatoires, but also without success. So then the second instance of this inclusion in this directive is even more interesting. So as you can see here, in paragraph 7 of the suggested reworked Article 13 on limit values, it actually said that member states introduce more stringent air quality standards in accordance with Article 193. So again, this is clear, but then it becomes very interesting. Shall notify them to the Commission within 3 months after their adoption, and such notification shall be accompanied by an explanation on the process of how those air quality standards have been established and the scientific information used. I found aha, what does that mean? This is not what is said in the treaty. So this is actually more remembering Article 114, which includes the grounds for notification. So what I did is I looked at the staff working document which was accompanying the proposal. And here they described that the purpose of this is, and I cite this, collecting information on technical and scientific knowledge and national or local standards surpassing the EU standard and enabling information sharing across member states. For me, this is actually a further formalization of the environmental guarantee, but it's also not only that, it's also really adding additional requirements which are way stricter than included in the treaty law. And I think it remains to be seen whether this is actually accepted or not. So whether, first of all, it will be changed again by the parliament, etc. Or I could also imagine that NGOs would, for example, challenge this. I don't know. remains to be seen. And second example, which is a bit similar but different, so similar yet different, is included in the Sulfur Directive. And as you can see here, Recital 14 lays down a straightforward articulation of the elements of 193 as included in the treaty. However, then Recital 15 includes super detailed procedural requirements for the notification of any new, more stringent protective measures by a reference to Article 2015-1535. So you get extra points in your examination when you can tell me what this Directive 1535 is about. I had no idea, so I obviously looked it up, and it's about laying down a procedure for the provision of information in the field of technical regulations of rules on information society services. Again, I had no clue. So in my opinion, already that reference to the directive may seen as a further instrumentalization and formalization of the environmental guarantee. But then actually I looked into this directive at question. And here, Article 5 of the directive requires member states to, and I also said, really immediately communicate to the Commission any draft technical regulation, except when it merely transposes a European standard, which is not the case most of the time in EU environmental legislation in the area. And this directive also arguably provides a further element of control by the European Commission, because in Article 5.2 of the directive, it provides that the Commission and also other member states may make comments to the member states which has forwarded the draft technical regulation, and hence by extension also the invokement of the environmental guarantee. And according to the same provision, the member states making the notification shall take such comments into account as far as possible in the subsequent preparation of technical regulation. So I think here it is really interesting to combine this with the Hacienda judgment. Remember, the Hacienda judgment was the judgment who said that a failure of the member states to notify a measure does not render the measure in itself lawful. So how this really increasing notifications, obligations, and making it quite technical can be interpreted in light of this case. And I think in general, the examples show that the environmental guarantee is really undergoing a process of further institutionalization and formalization. And I'm really looking forward to getting your thoughts before I have one more example, and then I will actually wrap up. And that is the Medium Combustion Plants Directive. And here again, in the recital, the first sentence is not so interesting. It's stating the opposite. But then the second sentence again got me question marks into my head, where it says that such measures may be needed, for example, in zones not complying with air quality limit values. In those cases, member states should assess the need to apply stricter emission value standards than the requirements set out in the directive. So as this can be seen, rather than providing merely that member states might adopt more stringent protective measures, here the directive itself signals the need as to when those measures should arise. So actually my question here is why this is not a substantive requirement in the directive if this is already so clear. So I'm really curious to also hear your opinions about this. As I said before, I've tried to do my best to make it clear, but in my own head, at least now these further references in secondary law get further question marks. So with that, I will briefly conclude and then hopefully open a debate. So I think in general, it can be concluded that the case law shows that the development of EU environmental law as a coherent body of law in its own right is actually preserved by the court. However, it implies that some constraints are put on the ability of member states to act more protectively than with the environmental goals, which actually seems to align with the intention of the drafters of the environmental guarantee. I've already highlighted those elements. So they need to attain the same objective, may not violate any provisions of the EU legal instruments, but also not the legal principles. And I think one could also say that the way in which the court has actually solved the disputes that have been arising in this case is really legalistic. So you couldn't say that it's really activist with providing lots of room for maneuver. I think it's really legalistic or sometimes even restrictive. What is to be further reflected upon or also kept an eye on, I guess, is the increasing formalization of the environmental guarantee in secondary law, which is putting more constraints onto the environmental guarantee than initially included in the draft in the primary law, and it's more and more resembling the one of Article 114. So I guess that's my conclusion. I have also included a list of sources for further reading. I think Lorenzo's publications are really worth delving into because he has a very, very good understanding of the issues. So thank you very much. That was my input for you now. I hope I didn't lose you with all the case law references, and I'm looking forward to your questions. Thank you very much. 86.